rate structure. So how do we plan? One of the things that one of the things that is available in planning through a revocable living trust is planning for your mental disability. That's Alzheimer's, stroke, etc. Another word for mental disability is mental incapacity. So unfortunately, or perhaps you don't know this, or many people don't know, there's not a definition through statute exactly of what it means to be disabled. There are a variety of ways in which your mental disability can be certified. In fact, for purposes of the trust, what we do is we build a disability panel. And on that panel, we do require that there's a physician on that panel. We don't need the name of that physician, but overall, a physician on the panel, and you would build it with maybe with your family members if you're married, the other spouse, if or your adult children, if your children are young, perhaps siblings or just close friends that know you, and they would take a vote as to whether or not you should still have control over your checkbook, so to speak, to be able to write checks. You know, if you are out there indiscriminately writing checks to people on the street or saying, "Hey, honey, it's great. This guy on the phone just tells me that I won the lottery in Jamaica, and all I have to do is send him a check for $5,000 for the interest." At that point, I think you would probably say, if I've said that, please take my checkbook away. I need help. And I do need to be supported and have somebody else administer my finances for my care. Okay. So those people, you would work together with the estate planning attorney. You would come up and build your disability panel. You can decide whether that's by unanimous vote, by majority vote, majority with spouse in the majority. We have all different ways. In the trust, you will also have some provisions as to, now that you've been deemed incapacitated, instructions to your trustee as to how you want your assets to be used for your care. Do you want to bring care into your home for as long as possible? Stay there. Perhaps would you like to go, if necessary, move to a nursing home, an assisted living facility? Do you want to live with your kids? And whatnot. So importantly, who will handle your financial affairs? So this is where you get to pick now, while you have your capacity, who that person is going to be. Okay. So what happens with no planning? If you have no planning and you lose capacity, you are that person who is writing the $5,000 checks to people in Jamaica for the interest on the lottery. At that point, your loved ones, the only recourse that they have, if you've not put a trust into place that has disability provisions in it, is that they will have to file a petition for conservatorship with the court. So a judge is going to decide for you, when you're disabled, who takes over control, what that person can do, who's going to take over your finances. And there's really no enforced reporting requirements, although the courts will require you to account in the first year, and thereafter once every 2 years will require the conservator to do that. In any event, it's very public, it's very long and drawn out. The courts are impacted if, for example, you have not planned and you are mentally incapacitated, you have a good amount of assets available for your care, but let's say maybe your adult children can't access those assets because you don't have a trust in place. You don't have the correct documents in place to allow them to access those assets for your care. Maybe they're going to have to come up with money of their own to pay for your care. Or if you're not even in that situation where you have family members to assist you, it's going to put you in a very difficult situation, not only for yourself, but those who care for you, care about you. Okay, so I know that sounds a little depressing, but this can be avoided by making sure that you do a thorough disability planning through your trust, and that's something that we do offer.